Is there.
Chair, honorable members, good afternoon. My name is Timothy Chumba Toroitich, Member of Parliament representing Marakwet West. Chair, before you, thank you for the chance to appear for this committee to prosecute this particular proposed amendment to the Advocates Act. Chair, I'm also an advocate, and Chair, before you is an amendment to the Advocates Act. Chair, the purpose of this amendment is to permit a person who is an advocate in the High Court of Rwanda and the High Court of Burundi to be admitted to the bar in Kenya. Chair, the justification to that particular amendment is anchored on the decision of the High Court of 2014. That is, that is the LSK versus the Attorney General and two others, which was delivered on 27th of September 2019, where the Court of Appeal declared some sections of the statute law, Miscellaneous Amendment 2012, for lack, it declared as the same as unconstitutional for lack of public participation. Chair, the sections that were struck down included amendments to Section 12 and 13 of the Advocates Act that allowed a person who is a citizen of Burundi and Rwanda to be eligible for admission as an advocate of the High Court of Kenya.
Honorable Kipchumba, thank you for this. Just one quick question. As you, two quick questions. As you correctly observe, the East African community encourages this kind of legal practice, cross-border legal practice, but in the same vein, it talks about, rationalizing legal training. Has this been done?
Yeah, we have the East African Bar, and that is the bar that could have rationalized legal practice in the East African countries, so that we have a uniformity in terms of minimum requirements in practice. So, Chair, in short, is as we speak, that particular provision allowing or permitting advocates of the High Court of Burundi and Rwanda to practice in Kenya is currently in our legislations. Chair, but the same was struck down in the Court of Appeal for the reason that there was no public participation in that particular miscellaneous amendment of 2012, which made it possible for advocates admitted to the bar in Rwanda and Burundi to be admitted as advocates of the High Court of Kenya. So, Chair, the basic, what I'm doing here is that I'm reviving that particular provision. Chair, as I've said, in our laws in Kenya as we speak, Chair, that decision of the Court of Appeal was criticized heavily. I have a letter here from Bernard Oundo, who is the president of the East Africa Law Society. Chair, for the reason that if you read clearly, the East African Common Market Protocol provides, among others, for removal of restrictions on movement of labor services, that is Article 5, and also that member states should commit to mutual recognition of academic and professional qualifications, that is including legal qualifications, that is Article 11 of the Common Market Protocol. Reciprocity is concerned. I think the East African community was founded on an element of reciprocity, that whatever we do, the other country should reciprocate. Chair, if you look at the two countries that I've mentioned, Rwanda and Burundi, under their laws in those countries, for example, in Rwanda, the legal practice is regulated under Law Number 83 of 2013. Chair, this particular provision, in particular Article 7 of that particular provision of the Rwandan law, it provides that foreign advocates can also practice in Rwandan courts where there is reciprocal arrangement between Rwanda and their country of nationality. Chair, as you speak, there are Kenyans who are practicing in Rwanda, pursuant to this particular provision. Chair, as you speak, even when this provision had not been struck down, because it is there in our law, There are advocates who had been admitted to the bar in Rwanda, and they applied for admission to the Kenyan bar, and they are currently practicing, even though they studied in Rwanda and were admitted to the bar in Rwanda.